Thank you all for joining today and welcome to this month's HR and Employment Law Update. We may have met with some of you before, but for those of you that we haven't, my name's Jamie and I am a Reward Business Partner on the People Advisory team. And I'm joined by my colleague Donal Moon, who is our Employment Law Advisor. There are quite a few updates to get through this month. So we're going to jump straight in, and today's session is going to run like a Q&A. So I've got a number of questions to run through with Donal. If any of you have any questions, please feel free to put them in the chat box and we'll get to them at the end of the session. If there's any that we don't manage to get through, we can reach out to you individually via email with responses to those. So this session is being recorded and you will receive a recording via email. In that email, there will also be our contact details. So if there's anything mentioned today that you would like to discuss further, feel free to reach out and we can go through that with you. So I'm going to kick off with you now, Donal. So to start with, are you able to tell us about the changes to the TUPE legislation?
Yes, so this is a massively employer-friendly change. So what's happening is that companies with less than 50 employees or companies that are any size but are carrying out TUPE transfers of less than 10 employees will now be able to consult directly with the staff instead of having to invite them to elect reps to consult with. So that removes a layer of complexity from a particularly complex process. So welcome change for employers there, I think.
Okay, so does this mean now that if a client were carrying out a TUPE transfer of less than 10, they would not need to invite the employees to elect reps?
Not quite yet. So these new rules only apply to TUPE transfers that are taking place on or after the 1st of July 2024. So any transfer happening before then is subject to the old rules. We are getting quite a few questions about that, with people thinking they can jump ahead now, but you can't, not unless the transfer is on or after the 1st of July 2024. The only exception to that is there is an existing rule that what's called micro businesses, so businesses that are less than 10 employees in total, can already consult directly with employees without having to elect reps, but they have to be a micro business to do that.
Okay, and will this change affect any other forms of consultation? So for redundancy or collective consultation for any other purposes, or is this solely a TUPE change?
Solely a TUPE change. All of the other types of collective consultation, such as the big one would be redundancies, you still have to elect reps for that purpose. I don't see that changing at any point. I think that will stay exactly as it is.
Okay. So I understand that record keeping requirements regarding working time have changed as well. What records will employers now have to keep, and how is this different from before?
Yes, so a while ago there was a Spanish case at European court level, and the ruling was to the effect that employers had to keep detailed records at individual level to show compliance with the working time regulations in terms of shifts, breaks, and time worked. So compliance with the 48 hours. The government was concerned that this was placing too onerous a burden on business, so they've now clarified that in the UK, what employers must do is to keep what's called adequate records. I appreciate that that's probably open to interpretation as well, but they now have to keep adequate records. So what you're trying to show is compliance at a general level with the 48-hour working week, opt-outs, health assessments for night workers, and length of night work. So much more employer friendly, I think, in terms of the records that have to be kept. Of course, it doesn't mean that you have to adopt a more laissez-faire approach. You can still keep the more detailed records if you wish to do so. In some cases, I would say more is more, but you no longer have to do so. And so I think small and mediums will definitely benefit from that relaxation of the rules.
Okay, so that does seem like quite an employer-friendly change, which I'm sure a lot of our clients will be happy about. So could you talk to us a bit more about the new rules regarding holidays and holiday pay?
Yeah, I'm sure many of our listeners are aware of this already, but for those who aren't, there was a case in the Supreme Court called Harpur Brazel, and it was about a part-time music teacher arguing that she wasn't being paid the correct holiday pay and that she wasn't getting her correct holiday entitlement. And what the Supreme Court said was that if you're a part-year worker, you have to be given your full 5.6 weeks leave, regardless of the number of weeks that you actually work in the year. So that caused as you can imagine, quite a stir amongst certain industries that use part year or seasonal workers. But the other kicker was that part year and irregular hours workers pay had to be calculated each time the person took the leave, using their ordinary remuneration, so including things like bonuses, commissions, etc., and working out an average over a reference period of 52 weeks. So it became massively complex for employers. So what the government's done, it was becoming concerned that the holiday pay and entitlement for certain types of workers was becoming disproportionate to the hours that they were actually working. So it's corrected this. What it's done is it's restored the ability to use a 12.07 multiplier to calculate holiday entitlement and pay. And the big change is that you now, instead of calculating every time you take leave, you used a fixed reference point at the end of each leave year, rather than having to do it each time someone takes their leave. So that massively decomplicates things for employers. And the other big change is that something that's unlawful at the moment is using rolled up holiday pay. So rolled up holiday pay is when you include an element of holiday pay for as part of someone's salary. At the moment, it's unlawful unless but you may be able to get away with it if you're transparent about what the person's being paid. So that usually includes including it, itemizing it on the payslip. But this change means that for part year workers and irregular hours workers only, you will be able to use that practice again, provided that you're transparent about what they're being paid.
Okay, so is that essentially a complete U-turn on the Harpur and Brazel ruling, or will some of the elements remain the same?
Yeah, so it is essentially a complete U-turn on Harper Trust and Brazil. I think that the government's main concern was that holiday pay for irregular and part-year workers had been made disproportionate to the number of hours they're actually working. So they've completely reversed that. The bit that still will remain, however, is that employers will still have to calculate the holiday pay, albeit in a different way, on the basis of ordinary remuneration. So it will have to include all elements such as commissions, regularly earned bonuses, regularly worked overtime, etc., etc.
Okay, and is it right that not all clients can implement these changes just yet?
Yes, that is right. So this new law applies only to leave years which commence on or after the 1st of April 2024. So that means that if your leave year starts on, say, January to December, which is quite common for employers, you won't be able to implement this change until next year, so 2025. One little wrinkle I kind of think some clients can tend to get caught out with is that some contracts can, not many, but some can be silent on what the leave year actually is. And if that's the case, I would encourage employers to check their contracts, because some leave, essentially what happens is if the contract's silent, the leave year commences on the date employment commences. So if you're in that position where leave year isn't specified, double check your contracts, because it could be that you can implement the changes for some but not others at this point.
Oh, that's interesting. And could you tell us a bit about the new right to carers leave?
Yeah, so that came into force on the 6th of April 2024. And so what it does is it entitles employees with dependents with long-term care needs to 1 week's unpaid carers leave in any 12-month period. It's a day one right, so you get it from the day you start employment. And as with all of these new kind of family-friendly rights, you got the right not to be subjected to a detriment, which basically means treated unfavorably, or dismissed because you're taking, or the employer thinks you're going to take that leave.
So will this replace parental leave, or can this be taken for any dependents that an employee has caring responsibilities for?
No, so parental leave is a completely different right. So parental leave is for specifically for the care of a child, and that's available up to the child's 18th birthday, and that will remain a right in addition to this new right to carers leave. Carers leave is about long-term dependents, not children necessarily.
Okay. And I understand there have been some changes regarding flexible working. Are you able to talk us through those?
Yeah, so that's right. So there's new rules in force again from the 6th of April 2024. Massively employee-friendly change here. So flexible working requests will become a day one right, whereas before you needed 26 weeks continuous service to claim it. You can now make 2 requests per annum instead of just 1. Employers have to formally consult with employees if they intend to reject the request. And applicants, and this is a key point, applicants no longer have to explain what the effects of their proposed working pattern will have on the business and how they propose to deal with any negative effects it might have. And also the decision-making period's reduced. So it was 3 months, it's now 2 months. So I think 2 months is fairly generous anyway, but for some employers that may cause an issue if they feel they need more time to consider, or depending on small businesses particularly, that may not have the resource to consider these things in such time.
Okay. And I understand that protection from redundancy for employees on family-friendly leave has changed. What does this mean for employers?
Yeah, so essentially what's happened is 2 things. So firstly, the protected period for people on family-friendly leave has been extended so that it now, instead of ending when the family-friendly leave ends, it'll now last until 6 months after the return from family-friendly leave. So that's maternity leave, adoption leave, and shared parental leave. So protection for 6 months after that. And for the pregnancy protected period is also particularly enhanced because by making it no longer apply from the moment they take their maternity leave. It now applies from the moment they inform the employer that they're pregnant. So there's that redundancy protection lasts for a lot longer in those cases.
So essentially, does this mean that once an employee returns from family-friendly leave, they cannot be made redundant for 6 months after their return date?
No, so that's not quite right. So we tend to have 2 misconceptions for employers in this situation. Some people think that when someone's on a protected period, they have to be put to the top of any selection pool, so that they don't become at risk. That's not the case. You have to conduct any selection exercise fairly objectively and in a non-discriminatory way. And it's when, if rather, the person on family-friendly leave in their protected period is found to be at risk of redundancy, that's when the duty to look for suitable alternative employment is engaged. But it's certainly not the case that they can't be made redundant. If there's a redundancy situation, then absolutely they can be. But there are duties and legal obligations that the employer needs to follow to make sure that they stay the right side of the law in that regard.
Okay. So I understand as well there's a new duty to prevent sexual harassment in the workplace, and that's coming in from October this year. What should employers be doing to prepare for that?
Yes, that's right. So from October this year, there'll be a new duty to prevent sexual harassment in the workplace. And it had been planned to reintroduce something that had been removed from the Equality Act called third-party harassment, but those provisions were, at least for the moment, defeated in the House of Lords. They felt it would be too onerous on business to comply with. I'll be watching this space to see if it comes back again, but for the time being, it's just the new duty to prevent sexual harassment in the workplace that's coming in. But I think there's a number of things that, although the law's not in yet, so some employers might be tempted to just react to the laws as they come in, which is, it's a valid approach. But if you wanted to start preparing now, I think the key point here is to show really that you have show and reinforce a zero tolerance approach to discrimination, and make sure that all staff are aware of it. So I think there's a number of things employers can be doing. So the first is to review your existing equal opportunities policies, and update them if they seem to be out of date, if they're old, if you think, well, actually that hasn't adapted to changing circumstances, we need to introduce new things into it. I'd say updating that now would be a good practice to get into, and update them regularly. Make sure that they're updated regularly. Now, I would always say possibly annually. They should at least be reviewed, to see whether they need updating or not, and then communicate the policies to the staff. I think that's one of the key things, because it's all very well saying we have a zero tolerance policy, but the staff have to know about it to be able to apply it, and not fall foul of it. But also another key thing that you could be doing is ensuring that your staff have equal opportunities and non-discrimination training. so that they understand that zero tolerance approach. I mean, in many cases, they may not have a complete grasp because they're not lawyers. They'll understand the basics maybe, but they might not understand what discrimination is legally, and what their obligation is not to do it. I mean, how many employees, for example, will know they'll know exactly about what direct discrimination is, sort of treating someone badly because of a protected characteristic, but they might not appreciate the nuances of reasonable adjustments. They might not appreciate the nuances of indirect discrimination, things that can land you in hot water in a tribunal inadvertently. So running that training would be worth its weight in gold, I'd say, and then rerun it regularly. Again, I would say probably annually. But again, that's a commercial decision for employers to make. But yeah, I have seen a piece of case law not too long ago where an employer tried to rely on equal ops training to try and say that they weren't responsible for an employee's discrimination, and the tribunal commented that the training was too old, it wasn't fresh, and therefore the employer couldn't rely on it. So, and that wasn't from memory, it wasn't that old. It was just a couple of years or so. So worth doing that updating and training on a very, very regular basis. Also, there can be some crossover between equal opportunities policies and procedures and other types of policies and procedures. So the ones that spring to mind for me would be things like whistleblowing, for example, disciplinary procedures, grievance procedures. All of those things are likely to have some crossover. So I'd say update those also, and make any relevant cross references between the policies, and again communicate those policies to the staff as well, so they're aware of them and understand them. And make it. I'd probably think about making it part of an induction process for new staff as well. There's no time like, I suppose there's no as there's no time like the present for existing staff. There's also no time like the present for getting new staff on board with all of those policies and principles before they join, so that they're compliant from day one and they understand what your organization's all about and how it treats discrimination. But I think another the key thing, and I think I'd have to say our company does this really well, is to get feedback. So although I think everybody thinks they're doing a great job on equal opportunities, sometimes the employee perception of that doesn't match what the employer thinks, and it's kind of important to get that feedback, I think, and see whether there are any areas for improvement. And I think implementing those areas for improvement could be really key in terms of compliance with this legislation going forward. The more you get yourself and the employees working in tandem and in agreement with these things, and implementing and just filling any gaps, I think the more you'll be able to reduce your risk of claims based around this new piece of legislation. So one method that I've seen used to do this quite effectively is employee surveys. It's not the only method, but it's one that I've seen used quite effectively to kind of ask directed questions at people to see how they view the company in terms of diversity, inclusion, and equal opportunities. So yeah, there is a lot of, in short, I know that was quite a long answer, but there is a lot that employees can be doing now, to get themselves ready for this.
No, I think it's really helpful to sort of let our clients know that there's sort of a multifaceted approach to how you can get ready for that. So how is this any different to what employers should be doing already? Or is it just that it's sort of been best practice up until now, and now there's a legislative requirement to do so?
Well, no, I mean, in all honesty, employers probably should have been who weren't doing all of these things should have been and were always at risk of claims. So there's always been the risk of discrimination claims. And I think if you weren't taking steps to stamp out sexual harassment in the workplace, you were always going to be at risk of claims, because a disgruntled employee could sue not only the company but any individuals who they believed were sexually harassing them. So that's always been a risk. And sex discrimination similarly, and possibly other claims such as whistleblowing and victimization. So companies are always at risk of these things, and should have been taking steps to eliminate any sexual harassment that occurred. But the difference is now we've got a specific new legal duty to take reasonable steps to prevent sexual harassment in the workplace. So that's an added bonus for employees, another avenue that they can use to bring a claim against an employer where they feel there's an environment of sexual harassment. So it'll be a claim in itself now, and I think it adds a burden. well and truly to the employer to take active steps. Whereas, yes, of course, they should always have been taking those active steps, but now there'll be a specific claim if they don't. And the trouble is, if an employee brings multiple claims, a failure in that area could lead to findings of failures in other areas.
In other areas, yeah. Okay, so I understand there's a new right to neonatal leave. Could you talk us through that a bit?
Yeah, so this is coming in. This is a really long time away, but it's coming in 6th of April 2025. So it's such a long time because HMRC needs to update its systems, and several statutory instruments need to be are required to be able to put this into place and get it ready. So we don't yet know what the notice requirements will be for this, so we don't know how much notice an employee will give, but I imagine that will become clear as the statutory instruments are published and possibly amended as they go through the processes. So we don't know what that will be yet, but we do know that the individual has to have 26 weeks continuous leave to claim it. They have to earn over, or at least rather, £123 a week. And we do know that it will be paid at the statutory rate for all of the other types of family-friendly leave. So, for example, paternity, maternity, so it would be exactly that same statutory rate. And the employee will be able to claim up to 12 weeks neonatal leave and pay. So it's and the key point is it must be for care of a newborn, and there'll be a requirement for the baby to have received 7 days of neonatal care within 28 days of their birth.
Okay, and do we know yet if employees on mat leave will be able to take that type of leave?
Yes, they can. Yes, they can. The only thing they can't do is they can't curtail their maternity leave, take the neonatal leave and pay, and then restart their maternity leave. Once maternity leave is curtailed, it's curtailed. That's the end. That's the end of the maternity leave. And the neonatal leave and pay would be tagged on to the end of the maternity leave. So what employers might see people doing, because you only have the right to 39 weeks maternity pay, what you might see some people doing is rather than have interrupted pay, they might curtail their maternity leave to the 39 weeks and then take their neonatal leave. So they're only off they're off for less time. So they'd be only off for the 52 weeks rather than 52 plus the tagged on neonatal leave. But it will just enable them to get uninterrupted pay. So that might be something that you'd see. I mean, it doesn't affect the employer particularly, but it's just something that you might see employers do, and wonder why they might be doing it, and that might be the reason.
And this is a question we get quite a lot. So if an employer enhances their maternity leave, would they also have to enhance their neonatal leave or any of the other types of family-friendly leave?
No, case law has been quite clear about that. That just because you enhance you enhance one type of family-friendly leave, you don't have to enhance another. And it always boils down to the fact that the purpose of each type of leave is different. But yeah, so case law has been pretty clear so far that there's no discrimination in doing that. Of course, there may be future developments that change that, but for now, no, you don't. No, you don't. You can have different rates.
Okay. So another one we've been getting a few queries about is any changes that are coming in regarding tips and gratuities. Could you give us a bit more information about that one?
Yeah, sure. So tips and gratuities are interesting. It's probably not talked about enough, and that's probably because it doesn't affect every employer, but it does affect a significant proportion, I think. So what's happened? So the changes were expected in July 2024, but news has just come out that actually that will be pushed back to October 2024 because the government's just published new draft guidance. So it has been a little bit delayed. It had been, yeah, like I say, it had been expected in July 2024. So what these changes mean is that employers have to allocate 100% of any qualifying tips over which they exercise control in the month the tip was received, without any deductions other than the usual deductions for tax and NI. And it applies to employees, workers, and all agency workers. There's also a requirement to have a written policy in place showing how qualifying tips are dealt with, and records of tip allocation have to be kept for 3 years from the date the tip is received by the worker. So you can still some employers use trunk systems, which are ways of collecting and totting up the tips that are received. And that's still possible, but what can't be done anymore is passing the admin cost of running that scheme over to the worker.
Okay, and in that sort of with that one, what would count as a qualifying tip?
Yeah, so these are tips that are either received by the employer or received by the worker, and they're either so the ones that's received by the employer controls them in some way, or they're connected to worker received tips that the employer controls in some way. So it's essentially where the employer. So for example, you could say if you give me a tip and the employer then says you have to hand that tip over to me so it can be redistributed to everybody, or if the tip is made to the employer and the employer therefore has sole discretion of how to allocate it out, those would be qualifying tips as I understand it. So
Okay then. Okay, and can you, or do we know of any more new laws expected to be implemented throughout this year and next year?
yeah, we had been expecting the right to request a more stable contract to come in. It hasn't come in yet, and all we know at the moment is that it's expected at some point in 2024. But that will be coming in. There was a part of me that thought that might be lost in the shuffle because some of the employment bill the plans that were to be included in the employment bill didn't materialize, and it was all the new workers' rights were advanced via private members' bills. So I thought this might get lost in the shuffle, but no, it is still planned, and it's expected at some point in 2024. The interesting point about that is it's not a right to receive a more stable contract. It's a right to request one. So the employer doesn't necessarily have to give it, but they do have to consider it reasonably, I would have thought. But we'll have to wait and see what the legislation actually looks like and what the obligations look like on employers, and then we can update people a bit better, I think, on that one. We're expecting some now this isn't necessarily my area, but I know that a lot of employers will be interested in it. But we are expecting some employer-friendly changes to GDPR. I think one of them might be the removal of the requirement to have a data protection officer. So that could be quite interesting and remove a requirement that some employers might find onerous. But I think Labour has some very interesting and radical changes proposed if they're elected. That probably deserves a whole webinar to itself, to be fair, but they do have some quite interesting proposals on that score.
Okay, so do you want to tell us a little bit about what the plans could be if a Labour government is elected?
Yeah, so essentially Labour published a green paper called A New Deal for Working People, and then a pledge was made at the TUC conference last year to introduce an employment rights bill within the first 100 days of entering office. So again, that doesn't mean that it's huge cause for panic. It just because nothing will come in within those 100 days. The legislation obviously has to be drafted and passed through Parliament, and that can take some time. But I think it's looking at the proposals, it's fair to say that it would be a massive paradigm shift in employment law to a much more worker-friendly environment. So there's a few proposals that I found quite interesting. So number one is a minimum wage that people can actually live on. We don't know what level is being considered yet, but I think from the wording that's being used, we can probably expect to see a rather substantial increase. I think it's without doubt that there'll be strengthening of the unions and perhaps simplification of the process for unions to be able to go into workplaces and organise and be recognised, and we'll probably see repeal of a lot of the current government's anti-union legislation, and particularly maintaining minimum staffing levels during times of industrial action. I think we'll certainly see that happen. There'll be a single enforcement body to enforce workers' rights. So that was something that was agreed under the withdrawal agreement with the EU, that there had to be such a body in place. And to an extent, we've kind of got that. But this body that Labour's proposing will have the power to inspect workplaces and bring prosecutions for certain things. So breaches of health and safety, and the national minimum wage, worker exploitation, and discrimination. And so what Labour's proposing, it looks like it'll have a lot more teeth than the current enforcement body. So that will be quite interesting to see how that develops. Labour's proposing a complete ban on 0 hours contracts. So at the moment, 0 hours contracts are not unlawful. What is unlawful within them is to have an exclusivity clause saying we won't give you any work, but you can't, at the same time, you can't work anywhere else. So that's unlawful, but the 0 hour contracts in themselves are not. Labour proposing a total ban on those, and also a total ban on firing and rehiring. So that's quite an interesting one. Firing and rehiring received an awful lot of bad press following some big name brands doing this. So I think so. Two particular brands that spring to mind are Tesco, which is currently embroiled in litigation with its employees over an allowance that it wanted to withdraw using fire and rehire as a potential threat, and also P&O Ferries, which P&O Ferries, which dismissed 800 people via video call, if I remember rightly, and in an attempt to replace their terms and conditions with something less favourable. And of course, it led to a massive political storm. And yeah, so Labour is the current government's approach has been to produce statutory guidance that employers should follow to consult properly with employees before using fire and rehire as a last resort if they really need to. Labour proposing a complete ban on that practice altogether, and they plan to do it by amending the unfair dismissal legislation. So much more of a commitment to try and stop this practice in its tracks. Labour's also proposing to reform employment status. So at the moment, we've got three types of employment status. You've got genuinely self-employed people with very little rights, if any, except under civil law. You've got workers who have a halfway house in terms of rights, and then you have employees who have all the rights. What's being proposed is to eliminate the status of employee and worker and replace it with just one status of worker. And that new status of worker will have all the rights, including the right to claim unfair dismissal. But on that note, there's also proposals to amend unfair dismissal legislation. So making it a day one right. At the moment, you need 2 years service to be able to claim it. The proposal is to make that claimable from day one of employment, or under the new regime, it would be work. There'll also be it will also apply, of course, to workers now that we've got that merged status. And the proposal is also to lift the hat on compensation. So at the moment, there's a cap on the compensatory award that most people can claim, unless with certain exceptions, but that cap would be removed. One interesting proposal was I've seen it mentioned that they may be looking at introducing a right to disconnect from work out of hours or during annual leave. So that's quite interesting. It's been done in a number of countries now. I think the most recent one I read about was Australia. But yeah, so a proposal to bring that in the UK as well. Now that could be quite interesting. But also again, focus on expanding even further flexible working rights. So I mentioned earlier some of the changes that the current government has made about that, but yeah, potentially going even further and making flexible working the default position. So so unless agreed otherwise, it would be the default position, is my understanding of what's being proposed there. But also, I think also for expanding the fields of family-friendly rights and equality and diversity is taken as a given. I'm seeing lots of noise around that. So some of the key proposals would be extending maternity and paternity leave entitlements. Labour's also said that they're not happy with the uptake of shared parental leave. I think they see it as quite low, but it's a very useful tool for parents and to have, or adopters to have. And trying to see what they can do to increase uptake of that particular right. So that could be interesting to see if they've got any initiatives that work to do that. But also expanding equality and diversity laws. So there's talk about including socio-economic groups as a protected characteristic. Introducing a new duty to report disability and ethnicity pay gaps. At the moment, it's just gender pay gaps that you have to produce, but there's a proposal to increase that to disability and ethnicity as well, and extending equal pay claims to ethnicity. So equal pay claims, of course, it's that's been criticised in some quarters because it's seen as, well, there's already duty not to pay unequally based on race. But actually, equal pay claims are particularly nuanced and complex. So it does introduce a new way of looking at equal pay that perhaps people with protected characteristics can pursue. But yeah, a lot to unpack there. I appreciate, again, that's quite a long list of things that's being proposed here, but it's quite interesting to see the proposals. Whether some of these get watered down, I don't know. There has been talk of some rowing back, but again, these are just rumors in the press about what's happening and how serious they are producing this. And I suspect we'll be getting more details as we approach the election, once parties start setting out their manifestos a bit more clearly.
It's certainly interesting to sort of hear about what the plans are. So we have had a few questions in that I will run through. So the first one was about the extended period after maternity. So someone has asked, if an employee were to take annual leave on the end of their maternity, would the protected period start from the end of their maternity leave or the end of the annual leave?
That's a good question. No, it would no. Remember that the protected period still sort of lasts for 6 months from the return after the leave. I don't think the annual leave wouldn't make any impact on that particularly. So it would still be 6 months after the scheduled return date.
Okay. And we've had one asking for some information around the case that you mentioned about discrimination where the training was considered. So I guess we could email that over. I'm not expecting you to remember that case law off the top of your head. So maybe I've got the name of the person who raised that question. So maybe we can email some information over.
Yes, we can. And I can give a quick summary of what the case was all about. So it was essentially it was a race discrimination claim. The individual was employed for less than 2 years and ultimately brought a claim. And the claim that he brought was on the basis of comments that had been made to him by 2 colleagues, which they described as banter. And I think ultimately what happened is the employer tried to get themselves out of it. And again, you'll see this from the summary that I send over. I'll send a summary about this, but the employer tried to claim that they weren't responsible for any discrimination because they'd given equal opportunities training. That's known as a statutory defence. It's very difficult to make out, but it's known as a statutory defence. You're saying we're not responsible for the acts of these employees, but what the tribunal said is that the training was stale. It couldn't be relied upon. And I don't think it was actually that old from memory, but it was certainly more than a year. So yeah, the employer failed in its attempt to absolve itself from responsibility for the discrimination because of the stale training.
Okay, there's me saying I don't expect you to remember it, and you've got it all there. So next question is, what are the statutory regulations regarding holiday work, or I'm guessing pay, for irregular hours and 0 hours? So I guess that sort of loops back to the Harpur Brazel one that we talked about.
What are the statutory rules for?
Regulations regarding holiday work and pay for irregular hours and 0 hours. So I guess just what will be the new norm going forward on the Harpur Brazel ruling?
Oh right, so I'm assuming a leave year starting on or after the 1st of April 2024. What you would do is at the end of the leave year. So assuming that could be the end of this. You know, if you have got a leave year on or after that time, it could be the end of the 2023 leave year. If not, it would have to be the end of this leave year to implement next year. What you would do is you would calculate the average of ordinary remuneration that this employee receives using a 52-week reference period starting with the end of the leave year. And what you would do is you would job back 52 weeks to try and get 52 weeks worth of pay data. And if you haven't got 52 weeks worth of pay data, then you can go back, but only as far to try and get it, but only as far as 104 weeks. So that bit remains the same. It's just that you're using a fixed reference point now, not doing it each time the person gets the leave. So then you would work out an average and use that to allocate to give the person a pot that you can say each time you take leave, this is what you will get. So it's just much easier for employers to do it this way. Much easier, I think. And you can use when they're accruing leave, you can do that on the basis of the multiplier of 12.07%, rather than having to do a complex calculation about the number of hours worked, etc., necessarily. Or just, and of course, naturally now we're no longer assuming that part year workers will have 5.6 weeks. You're doing that same accrual calculation that you would for any other member of staff using that 12.0%, 12.07% multiplier.
So the next question
hopefully that's helpful.
I think so. I think you've sort of gone through what the workings will be there. So the next one is, how can we ensure that new employment legislation or policies are implemented in a way that safeguards the scope of responsibilities within a role?
Sorry, within what contexts?
So I guess just how do they go about implementing these new policies, it's sort of making them part of the new norm?
Do you mean, is that in reference to the sexual harassment?
They haven't made reference, but I'd assume so. That's sort of the biggest shake up to policy, isn't it, in these all that we've discussed?
I think so. I think that's quite a difficult question to answer. I'm not entirely sure what the context of it is.
Okay,
but
well,
if you're, I mean, I think in essence, you most of these policies and procedures will apply to every role. So therefore, if you have I think I'd probably start with let's put it this way. I would start with probably a top-down approach. So you would look at the organization and what the policies and standards mean for the whole organization, and then you would start drafting around, and then you would look at that. Then you would look at each potential department and see how the law applies there, and see if there's anything additional to add in there. And then I would move down to the individual roles and say, is there anything about this law that applies specifically to this role, or anything that we need to adapt to make sure that that's the case? That's the approach I would take. So I would always use a kind of top-down approach to that type of analysis. I think I've understood that question, but if not, more than happy to go into further detail if the questioner would like me to.
So the next question we have is, can we prevent teaching staff using shared parental leave and curtailing this to obtain payment for school holidays?
No, that's an unfortunate nuance of the shared parental leave. I mean, one would assume that people are more conscientious than that, and they wouldn't be doing that type of thing with the system. But it is possible to do it. It's a wrinkle I heard of when the legislation was being increased. It's just it's a right that people have, unfortunately, so they can do that.
Okay, and the last question we have is there any legislation, or will there be, mandating all employers must provide mental health training to all of their employees and ensure this is usual practice?
There's nothing that I'm aware of about that, but I think I would be shocked if that didn't form part of Labour's plans going forward, because it just looks like they're certainly focusing in on issues of race and disability particularly. So I'd be surprised if something didn't come, but I'm not aware of anything at this point.
I think with such a spotlight being on well-being as well, it's something that wouldn't be a surprise if it was something that was implemented, would it?
Of course, and I think going back to what I said about the sex discrimination point and the sexual harassment, that's probably something that, again, I'm conscious that a lot employers have issues around cost and sort of and time burdens, but it's probably something that if you do end up in a tribunal, they would be expecting you to have done something in that regard already. And as you say, there's a lot of focus on well-being. So not a bad practice to get into, even if there isn't legislation, because it can reduce your risk of claims to do those things, I think.
Yeah. So that is all the questions we've had come through. As I mentioned at the beginning, the recording will be sent out, and both mine and Donal's contact details will be on there. So if there is anything you'd like to discuss further, or any other questions you'd like to take offline, please feel free to pop them over to us, and we'd be happy to discuss further with you. But other than that, thank you all for your time, and we hope you enjoyed our webinar. Thank you.
Thank you.